Assalamualaikum warahmatullahi wabarakatuh. So welcome to, this is part 3 of the lecture for the topic restraint of trade. So in part 2, we stop at the case of Nadenfal and Maxim Nadenfal, in which the court actually explained and applied the rule pertaining to reasonableness. And then eventually the court ordered for the severability, to sever the void part of the covenant, and the rest are actually was held to be valid. It's valid. I mean, the restraint was reasonable. So the question now is that whether the concept or the rule pertaining to reasonableness here is actually relevant or applicable under Contracts Act 1950, which is our Malaysian law. So the answer is actually yes. Okay, not strictly no. So it's yes. It's relevant, but only for certain restricted situation here. So reasonableness here is relevant to Malaysian law within the purview, within the scope of exception 1 to section 28. Okay, if you refer to your Contracts Act here, okay, it has to be with you. Go to exception 1, okay. You read through exception 1, and then there is proviso here from the word provided. Okay, I reproduce it here. Okay, right there. Okay, provided that such limits can appear to the court reasonable. That's the word reasonable. Okay, regarding to the nature of the business. So if the limits, okay, the local limit is reasonable, then actually yes, the court will allow such restraint. Okay, which is saving agreement. Remember the assumptions. So meaning that here it's possible to put the restraint clauses within that particular situation. So, and then now we move to the next exception under Contracts Act, under Section 28, Contracts Act 1950, Exception 2, Exception 3. So basically it relates or revolves around partnership agreements. So the principle can also apply to clauses in partnership agreement, okay, which restrict the future employment of partners who leave the partnership. So generally, for post-employment contract, we apply the general rule, which is section 28 generally, okay. But if it relates to prior to dissolution, okay, all right, exception 3 here, saving of agreement, okay, or even during continuance of partnership, then the restraint clauses are considered as valid. Okay, we don't apply section 28, the general rule. And then for contracts of employment, we have discussed a little bit, okay, in part 1 and part 2 of our lecture. So whereas sale of business are usually negotiated between equal, usually whenever it involves vendor purchaser, they have the freedom to actually negotiate the terms that they want to incorporate into the agreement. But whenever it comes to employer-employee, okay, employee usually stand on the weaker bargaining position. Okay, employee cannot really actually dictate, okay, the terms. Okay, usually the terms will be dictated by specified by the employer. If you want to work here, then you have, I mean, employer might say, if you want to work here, you have to agree with all the terms here. Okay, we cannot negotiate. You cannot say no here. So, even if the employment contract contains a restraint, so the employee cannot say no, have to sign the agreement, okay, cannot resist a restraint clause which is incorporated into the employment contract. So such clauses usually, okay, it restricts the type and location, like what happened in Riggles and Anthony Wilson, okay, type and location of employment, which may be entered into by the employee after the employee has left the employer's business. So even after post-employment contract, okay, there could be restraint clauses in which the employee must sign, okay, when they started to work with the employer, okay, when they signed the employment contract. All right. So, in determining what interest an employer may legitimately protect here, the court have limited them to 2. So, in these 2 situations, okay, the restraint could be valid. Okay, we have discussed about trade secrets, okay, in the earlier case, and then we also there could be situation. Okay, I mean the legitimate interest of the employer is to prevent an employee from soliciting the customers of the business. It's possible to restrain the employee in these 2 particular situations. Okay, we have another case. Actually, the case is from Singapore, and then the case from Singapore here, it applies the concept of reasonableness, okay, which is the rule under English law. But eventually, the rescind was considered as we will see whether it's valid or what. Okay, the court held that in this case, a covenant which was reasonable between the parties was void on the ground that the covenant was unreasonable in the interest of the public. Because why? The reasonableness here must measured from the two perspectives. Okay? Is it reasonable between the parties? Yes. And then is it reasonable for public interest? Okay, let's say no. Then the contract, the covenant will become, the rescission will become void. It's not valid. Okay, so the action here, the suit was brought to restrain the defendant, who was defendant, a former employee of the plaintiff, from doing what? From continuing to commit a breach of restrictive term contained in the written agreement. So by the agreement, it was provided that the defendant, the employee here, on leaving the services, here is post-contract, okay? Post-employment contract here. On leaving the services of the employer for any reason whatsoever, okay, either pursuant to this agreement or any breach of this agreement, okay? So the employee here, okay, agreed that he shall not carry on business of what an exterminator or fumigator, okay? Location anywhere in the island of Singapore, okay, either by himself or in partnership with others. Meaning, after you resign from this company, you cannot start the same business which will compete with the business of the employer, right? And then this is continuation. Okay, nor shall he take employment with any person. Cannot become the employee of any other company. Okay, firm or corporation carrying on the business of what exterminators or fumigators or any such similar business until, so that's the duration, until the period of 3 years has expired, okay, from the date of the employee leaving the services of the employer. So the court, in examining the dispute here, okay, the issues, so the court took into consideration that the plaintiff company was the only firm of fumigators in Singapore. So it's like monopoly, okay? There's only one company with that particular service here. So the court came to the conclusion that yes, although the covenant was reasonably necessary for the protection of the plaintiff business, okay, with regards to space and time, as well as the nature of the defendant's employment, but the court said, well, for public interest here, there should be more than one firm of fumigators in Singapore. Okay, we cannot, if it's better, if it's not monopoly, okay, it's better if we have choices of the companies here. And that to prevent the defendant from carrying on as a fumigator would be unreasonable in reference to the interest of the public. The public need more than one company offering the similar service of fumigators. Okay, remember when we discussed about the type of agreements, okay, we have 1, 2, 3, okay, and then the number 4 is meant to cover other commercial agreements, okay, whether we can apply section 28 or not, okay. So this is the case which is relevant to our discussion. Very, very old case here. Hua Kiao Steamship Company Limited and Chop Guan Him, 1930. So the court in interpreting section 28, so the court took a liberal attitude that these covenants are not in restriction of trade. So the court won't simply apply section 28 in all contracts, okay, even though it contains certain restriction clauses here. Because why? A strict view of the section would have the effect of invalidating most commercial agreements. If we were to apply section 28 to all commercial agreements, then it won't be valid. It will be void and not enforceable, even though the parties have the freedom to actually put in whatever clauses that they wish to, okay, when they sign the agreement. Okay, let's have a look at the facts here. Plaintiff contracted with the defendant and several other traders to charge them at a lower rate, okay, the steamship owner basically, in consideration that they, the customer, okay, would ship all the goods and produces from Muar to any port, to which the plaintiff had a steamer running, okay, steamship here, by the steamers of the plaintiff. Okay, if you use my steamer, okay, I'll charge you lower rate, okay, provided you have to use my service. That's basically the agreement between the plaintiff and the traders, the customer of the plaintiff here. And then the contract contains a covenant that, okay, if the defendant, okay, or the trader or any of the others transported their goods through another company, they will be entitled to claim rebate. Okay, if you use other steamer, okay, you cannot claim for the rebate. Rebate is like discount, okay, but it has some slight difference here, which otherwise they would have been entitled to. And if you, because you agreed to use plaintiffs, I mean, because the traders agreed to sign the agreement and agreed promise to use the steamship company, okay, and you could be liable to, I mean, that's what the plaintiff said, okay, they will also become liable to the plaintiff to pay 3 times the amount of the weight of the goods shipped by them in breach of the agreement. If you breach the agreement, you choose other steamer, then you have to pay 3 times. It's like penalty. Okay, you cannot use other steamer because you agreed to use my steamer. That's basically what the steamship said. I mean, the owner. So, the defendant, the trader, breached the agreement and the plaintiff claimed for the recovery of the sums of money due, the triple payment, right? And when they were being sued, the trader raised up the defense that, well, this is restraint of trade, okay? It is void, okay? You cannot put the restraint on us, okay? But the court held that the covenant actually was not a restraint of trade. So, because you agreed to be imposed with the triple payment here, all right, you cannot actually challenge it later by saying it was under section 28. It's not, okay, it's not really within the purview of section 28. So basically the restraint was valid. Okay, that's all for the topic. We have covered the topic of agreements in restraint of trade. Let me stop share first. Okay, so after this topic, we are, for the syllabus of Law 1211, we are left with 3 more topics, okay, to be completed together. And the 3 topics, they are all quite interrelated. Okay. With that, thank you so much for listening. So hopefully you are able to understand, follow, and digest. Okay. Assalamualaikum warahmatullahi wabarakatuh.